Hey, what up, y'all? Um, I've been meaning to get around to this Karen Reed. I apologize, I haven't gone around to it, but now that I able to get around to it, I'm gonna go ahead and take care of that now. And shout out to Emily D. Baker for this. And little that I knew, she actually has a separate channel that breaks that's is basically a recap channel of court cases, and I'm gonna be talking about the last week of what just passed. This is day 18, 19, and 20 in this recap. So with that being said, let's go to day 18, and once more, shout out to Emily D. Baker. Let's go.
Trying as its wireless vacuum.
We are on day 18. It's May 19th. We're always just off by one this trial, but it is day 18, May 19th. It's Monday. Remember, this week is a little bit of a different week because the court has some time off. So Thursday, Friday, the court will have a half day Thursday. Friday is off, and then Monday is off of court, so there's a 4-day weekend there. But we should have full days Monday, Tuesday, Wednesday. As we're getting, it seems, to the close of the Commonwealth's case. What is left in the Commonwealth's case is the big question, because I don't think they're going to
Yeah,
go
the
anywhere else
case,
that was at the
this
waterfall or at
case,
34 Fairview at this point.
this case, I believe, will indeed be finished up by the 1st of June. Just throwing that out there.
Because it would be really out of sync with where they're at in the evidence. Does that mean they're not going to? No, it doesn't. But could they? Sure. It would just be weird. I don't know, because I watched the first trial and all the motions between that trial and this trial. If this trial is resonating differently with the clips from Karen Reed, I think that's a big change. And with how pared down the evidence is. We can't even really call it the butt dial trial because the extent of the butt dials hasn't come in before this jury. A few, yes, but the extent of it, no. There's a lot they don't know yet. So, will they? I don't know. Can the Commonwealth choose to do that? Yes, they can. The Commonwealth can choose to not call witnesses all day long. The defense can choose to call them. But the Commonwealth can choose to not call witnesses all day long. I don't know what we're going to do this week, but I imagine there's more scientific evidence ahead of us, because I know from the last trial that we are not done. Next witness.
Almost next witness is Shannon Burgess.
Burgess. Where have we heard the name Burgess before? Well, in all of those motions about Aperture.
So I did, again, reviewed a vehicle forensics report by AG Speak. I reviewed documentation that was identified to me as evidence review. Prior testimony of Trooper Garino. And I reviewed some surveillance videos as well as a report by Mr. Whiffen.
So the Commonwealth called their first Aperture expert today. Who saw that coming? Not me. Witness number 35 is the tech Aperture expert, Burgess. This is the expert that we have heard some arguing over from Alessi and Brennan over the last few days, last week of court, because this expert is the one who correlated the times between the Lexus clock and John O'Keefe's phone. Here's what went down during direct examination. I found it easier to follow than the last time evidence was presented, but we went through the chip on, the chip off, the fact that apparently the Commonwealth's last expert completely missed that there was a micro SD card on the board and didn't take it off and evaluate it. Last trial, we had to go through all the different keystroke logs to try to figure out what the fuck, and it was so confusing. This trial, they have the Lexus clock data, so they can correlate the Lexus clock data and the tech stream data. What do I mean by that? In the vehicle, when the infotainment system goes on, the expert testified that it takes about 3 seconds from the power button to go on to the infotainment system to register that the car is on and show the time. So there's about 3 seconds from button push to like Lexus logo going on the screen and the clock saying the car has turned on. Those turn on, turn off times of the vehicle have been correlated to a bunch of different things in this trial, including Karen Reed leaving One Meadows Ave, returning to One Meadows Ave, returning to her parents' home in Dighton, etc. So they take the Lexus clock and when the car turns on and when the car turns off and look at that. Within those windows of the car going on and off, there is a text stream data stream. And the text stream data stream just starts on a count up from the time the car turns on. So within the car turns on, car turns off, if you're driving around for 20 minutes, car goes on and it just starts counting up. Car goes off, you would see it's like 20 minutes. So what they need to do with the Lexus data is take the time that the vehicle turns on and off, the key cycles, I would imagine, and then take the text stream time and correlate those two together. So if you have a text stream event at 12 minutes, and then you have the Lexus on time, you need to take the 12 minutes and see what that would be in real time, not just count up time. So then you have the Lexus data. Then you have the Lexus data showing different triggering events, including a 3-point turn. Did they ask why that was a triggering event? No, they didn't. They didn't ask at all. Could be a lot of things. Could be change of speed, could be whatever. They didn't ask. We don't know. Maybe it'll come up on cross. And they took the 3-point turn where it looks like Karen Reed overshot Fairview and made a turn and came back and correlated it to the data on John O'Keefe's phone. Because John O'Keefe's phone showed, and they brought up the chart on his location data, showing that the phone was traveling at a consistent speed, then slowed down, then went to 0, and then the heading shifted, and then the phone started registering speed again, traveling the other direction. So they were able to take the triggering event from the Lexus text stream, correlate it to the Lexus clock, what time it was, and then John O'Keefe's phone, and the location data on John O'Keefe's phone, and correlate it from Waze to John O'Keefe's phone clock, and then correlate the two. Though Brennan kept saying sync the two, they're not trying to sync the two, they're trying to correlate the two. The expert said that correlation was 21 to 29 seconds between what's going on in the Lexus text stream data, then correlated to the Lexus clock, and what's going on John O'Keefe's iPhone, which was running faster than the Lexus clock. We're going to hear more about it as we get into cross, and I'm sure we're going to hear a lot more about it. This witness was asked, why did you look more into correlating the phones? He said originally we didn't look at it because we looked at the Ring video and all of this, and a 1-minute variance between clocks is assumed or normal within the forensic community. So he didn't think there was any controversy, my word, not his, around the fact that a 60-second variance is incredibly normal. But he said he saw a report that correlated the times in a way that he thought was misleading. And in the time in that report, which I think is the defense expert report, he did not say that specifically, I think that's the defense expert report, he then went back and looked at more data because he thought that the other information was misleading and it needed to be corrected.
Oh, it's here.
Received was misleading and it needed to be corrected. So Brennan asked quite a lot about the time correlations. What was notable to me is that the PowerPoint included information about John O'Keefe's phone. I don't know if new PowerPoint slides were turned over to the defense. I'm sure the defense will ask about it on cross, or if those PowerPoint slides with the time variance were included when this PowerPoint presentation was initially argued over, which was a few months ago now, because Alessi was arguing about this witness and the fact that his opinions had not been distilled down for the defense. They just got like a 400-page PowerPoint. So I imagine when we get into all of the cross, we are going to hear about correlating the time, why he looked at it, if he watched any other testimony, but he would have been given the data from Whiffen when Whiffen's report was done, which he said was in January. We will see. Why does it matter? Because when we get to the accident reconstruction, this is the foundation for the Commonwealth to argue that the backing event correlates to when John O'Keefe locked his phone for the last time. Because John O'Keefe's phone, per Ian Whiffen's testimony, at 12:31:52, John O'Keefe's phone was in a pocket state. At 12:32:03, the pocket state was cleared. At 12:32:04, Face ID unlocked John O'Keefe's phone. At 12:32:06, John O'Keefe's phone registered red to a text message from Jen McCabe that said pull behind me. And at 12:32:09, the phone device was locked with a button. So they are saying that the backing event on Karen Reed's phone, time-wise, would correlate between 12:32:04 and 12:32:12, with John O'Keefe locking his phone in their PowerPoint, they said for the last time, at 12:32:09. That is why this matters so much to both sides, because we are laying the foundation for when the accident reconstructionist will argue that this collision took place. We know that the defense is going to argue that no collision took place. We know that the Commonwealth is going to argue that a collision took place. I think we're getting to a clip or a sideswipe. Okay?
And in both of those CVs, you indicate that you have not yet earned a bachelor's degree.
That is correct.
And you certainly have not earned a Bachelor of Science degree in any educational field, according to those two CVs, right?
Correct.
And in fact, as you sit here today, you do not possess any bachelor's degree.
Correct.
You have a public profile that's published on Aperture's website, correct?
Yes, I do.
And it's in the form of a biography page.
Yes, I believe so.
And that biography page has your education listed.
Very possible, yes.
You recognize that document.
Yes, I do.
And
What is
indeed,
it?
that is the bio page that's published on Aperture's website, correct?
That is what it appears to be, yes.
Now, I would like you, sir, to turn to page 2 of that document.
Okay.
And I'd like
And
to
say
your focus
about you on your website.
It states, am I correct, BS, Mathematics, and Business Administration. Is that right?
It does say that, yes.
And there is no qualification that is currently pending. It states BS in Mathematics and Business Administration, right?
That's what it states there, yes.
And you do not have a Bachelor of Science in Mathematics and Business Administration, do you?
No, I do not.
So they're looking at the LinkedIn now.
Go right to the second page, bottom. And under
just
education, it
embarrassing.
says University of Alabama at Birmingham. It's got a little UAB
Logo.
acronym there. And it says Bachelor of Science, paren, B period, S period, comma, Applied Mathematics and Scientific Computation, 2016-2018. Do you see that, sir?
Yes, I do.
That's not correct, is it?
No, it's not correct.
And you do not hold a BS in...
Can't you put on LinkedIn if you went to school for a couple years and didn't finish your degree? Can you indicate that on LinkedIn? Because I don't know.
Bachelor of Science in Applied Mathematics and Scientific Computation from the University of Alabama at Birmingham, do you?
I do not. And that would have been, at that time, an expect...
Chat has all said you can absolutely indicate if you went to school, because 2016, that's 2 years for a 4-year degree.
And you do not hold a BS in a Bachelor of Science in Applied Mathematics and Scientific Computation from the University of Alabama at Birmingham, do you?
I do not. And that would have been, at that time, an expected graduation date.
So it would be expected.
You are correlating clocks down to seconds. And you are telling me that would have been an expected degree date in 2018? It is 2025. How many courts have you testified in? How has this never come up until now? I
Yeah.
can't even believe this would never come up until now.
Yeah.
In ancient days, the man with the best beard was in charge. But in modern times, enough was...
How has this never come up until now?
Yeah.
I can't even believe this would never come up until now.
You prepared your May 8th report on your... If those were your words on your direct
On your
testimony,
own.
correct?
Correct.
So they didn't ask you to update a report? Like, I need more explanation.
First line of your May 8th, 2025.
Goody.
Okay. Have you Do you have it in front of you?
I do, yes.
It starts, Dear Mr. Brennan. You see that?
Yes, I do.
Pursuant to your request. That's a request.
Pursuant to your request.
Yes, I do.
I backed it up.
Pursuant to your request. That's a request you're referring to, Mr. Brennan, correct?
Correct.
I have completed an additional analysis concerning the above referenced matter. To formulate opinions, the following additional items were reviewed. This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
What?
You're explaining?
Really,
Brennan said
dude?
he was surprised by the report, and he's saying I just copy and pasted it. So now we have typos and everything. We have direct lies
Really,
in
dude?
the CVs
You're
and
a
the website,
jackass.
and we have like, oh, that was a typo. Oh, this was a typo. Sir, you're expecting us to believe that you are accurate down to the seconds. But it's just like, oh, that was a typo. Oh, I copy and pasted that. Oh, yeah. I didn't think it was going to get worse. It keeps going.
In your initial report, you stated that
Oh,
the December
dude.
2023 data acquisition was from the Spansion clip, S-P-A-N-S-I-O-N, from the infotainment model was incomplete because the acquisition was only 8 megabytes in size, even though the chip has a storage capacity of 64 megabytes, correct?
Yes, that is correct.
And that's your October 10, 2024 report, correct?
Protocol.
I'm sorry, what was it, proposal or protocol?
Protocol.
Protocol?
Protocol.
We'll use protocol. And you blame this on the, quote, programmer's inability to fully read the component, close quote, correct?
Correct.
In point of fact, the manufacturing specifications establish that the total flash memory component of the chips in question is equal
I'll be
to
back in a
64
second.
megabits, not 64 megabytes, correct?
That is correct.
64 megabits is 8 megabytes, correct?
That is correct.
That means the Spansion chip was not incomplete, correct?
Correct.
The acquisition was the same data size as the total memory storage capacity of the chip, correct?
Correct.
Your protocol for data acquisition was based on a misunderstanding of megabits versus megabytes, correct?
It was based on a working theory and a misinterpretation, yes.
And that was your misinterpretation.
Yes, it was.
The end of day 18, the complete implosion on cross-examination of the Commonwealth's witness from Aperture, I don't think is me being hyperbolic or overstating it, because the jury will get an instruction at the end of this trial with the jury instructions telling them how to evaluate witness testimony. And if witnesses have been impeached or if they did not believe witnesses on the stand, when they talk about witness credibility, they will be told that if they do not find a witness credible, they can disregard some or all of that witness's testimony. And when we got into it today, Alessi just step by step by step by step went through this expert's CVs or resumes. And as they were going through the resumes, it was, you have this one that was provided to the court and counsel, and then you have this one that was provided to the court and counsel. And on those two different ones, it says that your BGS, Bachelor of General Science, asterisk, we'll come back to that later, is in progress. And then it was, well, on your company website, Aperture, the company that the Commonwealth hired here, it says that you have a BS degree in mathematics and business administration. And on this other resume that you can download from your company's website, it says that you have a degree from 2022. But then on LinkedIn, it says that you obtained this degree between 2016 and 2018. Yes. Wait, that degree's not been completed. No. Well, when did you start working on that degree? 2007. As they were going through this part of the cross, it then comes up, are you aware that someone can look on your LinkedIn, or you can see who looked on your LinkedIn? Yes. Are you aware that anyone from the defense team looked at your LinkedIn? And he's like, I'm not aware of that. Are you aware that on your profile page, on your company's website, the little linky-do that you push that says LinkedIn to take you to your LinkedIn page does not work at the moment? I was like, no. He's like, were you aware that that change was made in the last 48 hours? He was like, no. I was not aware that that change was made in the last 48 hours. And it just continued to roll downhill from there. We got into the questions about the updated May 8th report. And the fact that the beginning of the May 8th report said, I am submitting this per your request. When Alessi asked, what request of the Commonwealth, Attorney Brennan, led you to write the May 8th report, he said, none. The May 8th report I initiated after reading the defense expert report. Alessi's like, well then why does it say per your request? The answer was, I cut and pasted that from another report. So the natural follow-up to that was, you cut and pasted it and didn't.
I've been following security cameras for decades, and I don't think anything has come as close to, man, I hate to say the word perfection. This is real.
You cut and pasted it and didn't verify that it was important. You don't think it's important, the distinction between you writing a report sua sponte and the Commonwealth asking you for follow-up? You don't think that's different? I have questions and thoughts, but I'm going to wait till the end of cross before I talk about them. Didn't think it was important, and it sounds like the May 8th report is not just like a itty-bitty little one-page report. It sounds like there was a lot more information in the May 8th report. This witness has maintained that the reason he wrote the May 8th report is to correct the time correlation based on the way it was interpreted by the defense expert. He said that he didn't think it was in question because everyone in the field generally agrees that a 60-second time variance between clocks is kind of standard. If you can narrow down the variance, why wouldn't you? And I don't know if everyone generally agrees, because at one point when he's asked about Ian Whiffin's report later in cross, he says that he learned about the pocket state designation on an iPhone, and the iPhone, we learned during this trial, has a pocket state and a pocket state cleared. He said he learned about those from Ian Whiffin's report. He also holds himself out as a phone expert and someone with Celebrate certifications, in addition to being a vehicle expert. Those aren't the only errors they got into. So the errors of, do you have a Bachelor of General Sciences degree or not, and then the fact that a Bachelor of General Sciences degree is not actually what the degree is. It's a Bachelor of General Studies, but it's been held out as a Bachelor of General Sciences in a number of the places that the defense pointed out. But it also got down to the bits and the bytes of it all. And this came up in pretrial hearings. This expert said that the reason he told the Commonwealth the work that needed to be done was because he looked at 3 different chips from Karen Reed's car and said, these chips hold more information, so those extractions can't be complete. Those extractions can't be complete because those extractions aren't the right amount of data based on what like the manufacturer standards are for these chips. Well, that wasn't accurate. It seems that the reason that this expert thought that there was a variance in the data downloads from those 3 different chips is because of their misinterpretation of the amount of data those chips should have by not properly reading the bits versus the bytes or whatever. So in fact, the data that was downloaded was complete and was the right amount of data for each of those chips. He was just wrong on the first draft that he sent to the Commonwealth, which makes me wonder, how much time is the Commonwealth being billed for? Not that I'm any big fan of the Commonwealth, but I just have to wonder as I'm sitting here listening to all of this, how many reports is Aperture billing the Commonwealth for? Because the first report was all based on work that seemingly didn't need to be done in the way that he suggested it needed to be done, because it was an oops. Well, we need to do all of this. Just how much padding is going into what they're billing the government? I have to wonder. Because they would have been billed for the first report and the second report and the May 8th report. And why are we billing for a report you're just writing on your own? Because generally the attorney would say, no more reports, and you would ask before. But no, this expert said he did not ask the Commonwealth about the May 8th report. He wrote the May 8th report. He said he didn't talk to anyone about the May 8th report before the May 8th report, except for on May 7th when he called Attorney Brennan and told him what was in the report. So you didn't talk to anyone before the May 8th report? No. Well, on May 7th, you called Attorney Brennan and told him all about your report? Yes. Okay, so you did talk to the Commonwealth about your report. Or was that not a conversation? And then he's like, oh, well, and I did ask Lieutenant Tully for the full download of the location data of John O'Keefe's phone. And well, unless he went back and forth on the expert about that, I actually don't disagree with the expert on that. When Alessi was saying, but you have Whiffin's report, I don't disagree that the expert's like, I have Whiffin's report, but I want the raw data too. I want all of that data. I'm not quibbling with him about that because there's too much else, including the fact that he had the defense report from the beginning of March. So if you have the defense report from the beginning of March, why did it take until May 8th to send a supplemental report responding to the clock variance issue to the Commonwealth? Like, why not April? We still don't have a clear answer on that in my mind. This is supposed to be one of the most critical witnesses for the Commonwealth. And I can't imagine what Hank Brennan is thinking at the end of today, because I have never seen anything like that in court. I'm gonna have to ask every attorney I know, and all of you that are watching, just put it in the comments. I have never seen anything like that happen. I have never seen an issue like that with a CV. The thing that concerns me is that this expert testified that he's testified in cases in numerous courts. And this is the first time this has come up. It's never come up before. That your LinkedIn says you received a degree, your company website says you received a degree, the resume on your company website says you received a degree, but the resume that you give to court says that you didn't. And then it's alluded that it's a Bachelor of General Science, which is different than a Bachelor of General Studies. Anyone who has a degree that ends in the word science is going to take massive issue with a general studies or a arts degree correlating to a science degree. What I have found from all of the science nerds that I know and love is that there's a lot of pride in how fucking difficult those degrees are, because there's a lot that goes into a Bachelor of Science that does not go into other type of degrees. So does it support an air of greater knowledge or understanding? Yeah, it does support a greater degree of understanding if that is your degree. So am I bothered about whether somebody has the degree or doesn't have the degree? No. What I'm bothered about the most is the misrepresentations in multiple locations. How the fuck does that even happen? I also have to wonder what rate his company is billing him for to government entities and to insurance companies, because he said he works with insurance companies. And I wonder if that rate is due in part to the expert's background, training, and experience. I just have to wonder, A, if the defense will get around to asking that, if this witness knows, and B, if other clients of this company are going to sit there going, wait a second, what? Or maybe it's not going to come up. Maybe this is an anomaly for that company. But in this trial with this expert, it is not good at all. I don't know if it will matter to the jury what he says about the timing. And this information came in a much more clear way than it did in the previous trial. It was presented in a much more understandable way. They did not correlate it to a time last time. Last trial, we were going through the key events, and then the tech stream events, and then it was, well, this one must have been when it went on the this, and this one must have been there. It was so choppy and so jumbled, and it was so hard to follow. This was much clearer. But once we get to this, how can you say that this expert is detailed, meticulous, and careful enough to pin the timing of when two things happened on? How can that be relied upon? Because he's like, oh yeah, that was an error in this. Oh yeah, that was an error in this. Oh yeah, I just kind of cut and pasted it in that. Okay, so the only time that you didn't make mistakes is this one window of time in your report? Because that's a lot of errors. And as to the CV, misrepresentations. And this witness said misunderstandings miss me. You know that putting the date indicates that you received the degree. Not that it's in progress. Not that you've done 4 units. Not that you had a semester. It indicates that you completed the degree. And after that, I don't know how the jury looks at anything that expert says and goes, yes, I can confidently rely on what this expert said to make a determination in a homicide case. Or does the jury look at it and be like, whatever he said, none of it? And then, does it also taint the opinions that rely on his opinion? Because I very well think that it can. What an absolute wild shit show today. And the shit show was being orchestrated by Alessi. Alessi was just like, let us begin. And walked through the questions on cross-examination to catch this expert in misrepresentations about his degree, not to the court, but everywhere else, errors in interpreting data when it's like literally your one job, typos and copy and pastes, and misunderstandings. How is it reliable? And cross-examination resumes tomorrow. So not only are we going to have more Alessi word of the days tomorrow, but this cross is going to last quite a while tomorrow. I think that this witness gave the defense what they need to argue. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.
Day 19.
You have BO, right? We all do. Introducing Mando Whole Body Deodorant for pits, privates, and beyond.
It's time to go to court for day 19 on May 20th, 2025 of the Karen Read retrial. Yesterday's cross-examination was one of just the wildest things. The expert not only admitted to errors in the way that they approached their task, they admitted to errors in their May 8th report, which I thought was an update report. It seems like it was a pretty thorough extra report, said that they'd never ever done that before, and also reported on their company website, on LinkedIn, and on their company's CV to have a degree that is not on the CV they provided to the Commonwealth and the defense. Does it matter if they have the degree that they say they have online and not to the defense? The degree is not the point. It's the holding yourself out as if you have it elsewhere. That's the point. And then, once you get there, everything is viewed with less generosity, because then you get to the issue with them asking the Commonwealth to do a bunch more work, to download a bunch more chips, or to re-download the chips, or to try to re-download the chips, to try to put the boards back into Karen Read's Lexus, because his fundamental error was he thought that they had not downloaded fully, because he misinterpreted the amount of storage that they had and how big those downloads should be. So when you're relying on a tech expert who is telling you that they don't understand the storage on the chips, I think it's hard to get beyond that for many. But he's back on cross today. We'll see if this will be the only witness today, because when you're Alessi, trying to finish this cross is hard, because you never know what else you might unearth.
And these are all your slides, correct, sir?
Correct. I will say, the chat clocked this quite a lot yesterday, but here's the problem. It does start with January 29th, midnight, and then into the 30th, so he has the front date and the back date wrong. No, that makes it worse. Because he's showing these things from the 29th overnight. The actual date was the 28th overnight into the 29th, not the 29th overnight into the 30th.
Is your analysis down to, is your analysis on slide 36 accurate down to the second, as you stated in your direct examination yesterday?
Yes, according to the Lexus, yes.
According to the Lexus.
Doesn't the Lexus have the date wrong?
In point of fact, Mr. Burgess, none
Of those
of
are
the
correct.
5 timelines that we just reviewed from your presentation are accurate at all, and certainly not down to the second. Am I right or am I wrong?
You are wrong.
Are you aware?
Sir, how did you not see the trap? That's for him
These
to figure
5
out.
timelines are exactly 24 hours off from the time where the event actually occurred, correct?
No. So these events occurred on January 30th.
What?
If I misspoke and said the 29th, yes.
Okay.
No! What?
Understand my point.
Yes. Yes, I do.
Idiot.
Unless he's like, how do I even cross him when he doesn't realize how bad it is?
The core basis of your job, your role in this case, is to reconcile time discrepancies, as you say, down to the second, correct?
Correct?
But your discussion of the timeline on each of these slides, on each of these key events, is incorrect, correct?
No, it's not incorrect.
So your discussion
The jury's got to be sitting there
of
going,
the applicable date, you're saying,
29th.
as you described it yesterday and interpreted this timeline, was correct? Is that what you're saying now?
This timeline is correct,
Well, my
yes.
question is your discussion of it yesterday.
If I misspoke and said the 29th, then yes, I misspoke on that, yes.
And that was your testimony yesterday, what you spoke about.
Yes.
Let's turn to a different topic. Lights up
Oh,
if we could, and maybe
my
take that down, Mr. Wong.
God.
We'll cut to the chase. Since the beginning of time, humans have been trimming their nails. So, why don't we really think about
Mr. Wong.
God.
Now, in your May 8, 2025 report, you abandoned the call log analysis from your January 30th, 2025 report, correct?
No, I did not abandon it.
Did you rehome it?
Depart from it, at least in some respects, correct?
I did not depart from it. I used another method.
Okay.
So the method you originally used, you no longer used. Is that not a departure? You changed methodologies. Which is making me even more mad when the court said, this is not new information. It seems to be a complete fucking change in methodology. He went from looking at when calls were received on Karen Reed's Lexus, infotainment, and calls received by John O'Keefe's phone, or calls made from Karen Reed to John O'Keefe's phone. And he looked at the timestamp on those two things and said, okay, this is how we're seeing how in sync these times are. And then instead of syncing it between infotainment calls and calls on the other phone, he started syncing it between Waze data on the phone and text stream data. How is that not a completely different way to sync events? Unless you're going to say the methodology is more broad and you're linking the phone to the Lexus still, it's different. Linking app activity and the car driving is different than linking the two different call data.
In your May 8, 2025
Oh, let's see the microphone.
report, instead of applying the
For
offsets
the love of my ears.
from the call logs, which discrete points in time that are fairly easy to compare, as you stated just moments ago, you decided to use, in your words, quote, approximate time of three-point turn as your anchor between the two devices. Do I have that right?
Yes, you did.
discuss a classic example of confirmation bias, which is to be avoided in science. None of the information in that black box indicates that there was a collision on any tip without more, correct?
Correct.
I'd like
Which
to now turn to...
I think cuts both ways, because the defense is going to argue that Karen Reed collided with John O'Keefe's vehicle, and it didn't register that either. What I have to wonder, he didn't review the data, what I have to wonder is, did the vehicle even register an event for when Karen Reed was backing out of the driveway? Because we see it on video. Did the car register an event for that or not? Because that you can say, okay, this is on video, and there wasn't even a trigger event for it. So it is 6 of one, half dozen of the other. We're at lunch. The Commonwealth's expert is still on the stand on redirect. There was a lot more cross to go. I think Alessi was incredibly productive on his cross-examination of this witness. And we learned again that when it came to the trigger information or the infotainment information or the text stream information, they're all synonymous, that this expert didn't have the raw data. He pulled the text stream information from Dr. Welcher's report. We still don't have a full explanation then of how they attributed the log events 1162.1 and 1162.2 to the different on-off of the car. We haven't heard how those have been attributed yet. Welcher might do that, but the reason this witness is testifying first is because this witness is the one who Welcher bases all the tech timing off of. So in redirect, as we thought he might, Brennan started with, you don't really need a degree to do the work that you do. You have certificates, and you've never said to anyone in court that you have a degree that you don't have. And this is what it says on your CV that you provided to the court, which said in progress, different than what the company website and stuff says. And Brennan asked, when did you write your LinkedIn? The guy's like, well, like 10 years ago. Did you write the website for your company? No. Did you have any input on that? No. Do you know how many people are at your company on the website? And he said, maybe 100 with 15 different offices for Aperture. Seems like a lot. But he said he didn't do any of the stuff that is on Aperture's website, and that his LinkedIn was done over 10 years ago and he hadn't updated it. And in all of his time testifying, this has never come up.
And again, shout out to
And in
Emily
10
B.
years he's worked
Baker.
for Aperture, this has never come up. I would imagine most expert witnesses would beg to differ that their LinkedIn and the way they hold out their professional credentials doesn't come up, but he says it's never come up. How the jury will take that information depends. If they think that the defense is being hypercritical about it, they might be like, well, the one he gave the court is accurate, and he didn't tell us that he had that degree. And he says he doesn't need the degree for his opinions. So they might disregard it. They might not. I think I'm going to be more critical of it just because this is the field that I work in. And so I have a baseline that's different than an average juror. My baseline comes from being a lawyer and being in court quite a lot and watching more cases than that. It's wild to me. But jurors who might have never served on a jury before and don't really watch this might be like, I mean, okay, the one he submitted to the court's accurate, so I don't see it as a big deal. They might not. For me, if it was just the resume, I might be less critical. The resume's wild. But then you get to the issues with the bits and bytes, and then we get to the raw data not being evaluated, and there's a lot of questions. But on redirect, Brennan is bringing up, okay, well, why do you disagree with the way that the defense expert's interpreting this data and where they're interpreting the data? And I think that testimony has been pretty clear. Whether the jury agrees with it or not is different, but I think the testimony with the redirect has come in clearly in a way that makes sense. He said, look, the defense expert is trying to align the clocks or correlate the clocks after 5:30 in the morning, and the information taken from the SUV's infotainment system when the car was off is just importing data from Karen Reed's iPhone. So that variance is going to be 1 to 2 seconds from John O'Keefe's iPhone. Okay. But his report just has it on a chart. The chart that we've seen, and maybe it's elsewhere in his report, the chart that we've seen doesn't note that that's what the differential is. It's confusing information on its face, and yes, he's trying to explain it. It's not there. It's just a bunch of data, and it's titled as infotainment system. And where we haven't gotten to in redirect, that came up quite a lot in the rest of Cross this morning, was that this witness, with all confidence, said that the timeline that he presented in court was accurate to the second. And the timeline shows from January 29th in the evening through overnight midnight to January 30th. And that is not the correct timeline. And he said, no, if this happened January 30th, January 30th, the SUV would have been sitting in Canton PD and John O'Keefe's phone wouldn't be doing anything. We haven't even addressed that yet, but on all of the slides that were shown yesterday, if you go back and watch yesterday, you will see that they show the timeline on the bottom of those slides a little bit, and then the Commonwealth zooms in to the videos that are correlated with that slide. It's all in evidence that those videos that are being shown came from January 29th, not January 30th. But when you are asking a jury to trust an expert, when it comes down to seconds, when is it too many errors for a jury to rely on that? Not having the date right seems like we are not paying close attention to the details. Alessi did I think, a good job of pointing out how much the details matter when you are dealing with seconds. And again, why does this testimony matter? Well, for the Commonwealth, it's the basis of when they say Karen Reed hit John O'Keefe with her car. And for the defense, it's the basis of where they say John O'Keefe's phone was still moving after the text stream data shows a backing up event. Therefore, at that time, John O'Keefe was not hit by a car because he was still interacting with his phone. And the injuries that he had would not allow him to be interacting with his phone. So if the injuries came from the vehicle, then how is he still on his phone? Because the time is different. So it is up to the Commonwealth to narrow in that timeline in a way that the jury finds reliable. The defense can say, how can you rely on this? And if they can't show you when the timeline is accurate, or if there are two reasonable explanations, could be this, could be this, then the jury's told they have to pick the reasonable explanation that points towards not guilty. Because the reasonableness goes to the heart of beyond a reasonable doubt. If there are no other explanations than this happened the way the Commonwealth said, then reasonable doubt loop has been closed. But if there are multiple reasonable explanations, then that reasonable doubt loop hasn't been closed. And the defense has been much more, I think, laser focused this trial on reasonable doubt versus the last trial. And the Commonwealth is trying to narrow in this case and the contradictions. There's a lot the jury does not know. There's a lot of witnesses that were called first trial that aren't called yet. And though we know it, if we've watched the trial before, the jury doesn't know it. So the jury, I'm sure, is sitting there still trying to piece together a timeline because they now have some vague idea that this 1162 is a backup event that may have been when this happened. And the jury, I'm sure, is sitting there still trying to piece it together because the puzzle's not clear to them yet. But on day 19 of trial, shouldn't the puzzle be more clear? So when are we going to get to Welcher's testimony? Because we've heard a lot about it today. And the Commonwealth seemed to indicate Welcher's testimony might be next week. So we got a long way to go. So who's the witness they call after this? Because it sounds like it's not going to be Welcher. Is it going to be the medical experts? It might be. The rest of today is going to be very interesting. But remember, the way we see things with the information that we have and the way the jury may see things can differ. And there's a long way left to go in this trial. But this witness has said, I never said on the stand I had a degree. I never represented that in any court. And this is how I parse the data. I find the explanation about the data more clear than I did last trial, but that's going to come down to how reliable this witness is viewed. It's going to be interesting to see how the defense expert that's going to talk about the same issue, DeSorga, I think, because it's been pronounced like 17 different ways in court, how those two things go together. Because the tech timeline is between this witness that's testifying today and the defense witness DeSorga. The accident reconstruction is going to be between Welcher from Aperture and Wolf and Rentschler from ARCA. I can't believe we are 19 days in and we've got a long way to go. But
Yeah.
also the Commonwealth's getting towards the end of their case. And it seems more and more like they are not going to call any more civilian witnesses.
Nope.
Which means they might not call the Aruba witnesses either. They might not call anyone else that was at 34 Fairview. They might not call, and it seems more and more likely that they won't call Proctor or Tully or Higgins.
I'm just gonna skip on to day 20.
It is day 20 of the Karen Reed case, and it is Wednesday, May 21st. Yes, we're just off by a day now, which is going to be really confusing until the weekend, and then we will resume. So we are here waiting for the prosecution's next witness, and it seemed that they were going to be calling a witness out of order this morning based on reports from yesterday, because they told the scientific witness that was on the stand from the trace department of the lab to come back later in the day because they were going to call a witness out of order.
So, an issue has come to my attention that it is going to make it next.
Again, this is Karen Reed, day 18, 19, and 20.
Necessary that I talk to each one of you individually over at Sidebar with counsel, so that process will take a little while. So I'm going to don't speculate as to what I'm going to talk to you about. Please, we can go back to the board, talk about anything but this case, and I'll see each of you individually, and the process will take time. The cameras will be shut off, and I'm going to talk to the lawyers. So, jurors, I still have a couple of questions for you. Were you able to follow the instructions and refrain from doing any independent research or investigation into this case? And we've discussed the other two questions, but I do need to stress for you that it's very, very important that no one discuss this case. Don't let anyone talk to you about the case, no comments about the case. You've seen how hard the lawyers have worked to pull this case together for you, and everybody's given it so much time. So please, let's make sure that we follow that. That means each other. So,
Is there anything about the pattern of that letter that there was a ridge or a line-type edge that caused that wound?
Not necessarily.
And have you seen, in your experience, similar types of lacerations and breaks caused by falling on hard ground?
Yes, you can see that both in the occipital region. You can see it if patients fall on their, forehead. The skin tears, they're still bridging, and then they get bruises.
Right.
Some of your work was in Minnesota.
Correct.
Was it a colder part of Minnesota?
Right.
Very cold part of Minnesota. It's Minneapolis.
He's like, it's Minneapolis.
These type of injuries there?
Yes, I mean, we took care of a trauma center in Hennepin County. Very frequently, patients that are drunk fall down on ice sidewalks.
Right.
And could develop, lacerations in their head, epidurals, which are blood clots above the dura because they fracture a bone in the temporal area and they can get a bleed from a fractured artery. And it happens when people are shoveling snow and have a heart attack and fall backwards. So there are various ways that people fall
Backwards.
resulting in head injuries and lacerations to their forehead or to different areas of their head.
Can somebody suffer this type of injury simply by falling backwards?
Absolutely.
Yeah, that's what he just said.
You had taken us through the
I don't
process
think
of
that's-
falling backwards.
I don't know if that's the answer Brennan wants, but that's the truth. Can someone suffer this injury from falling backwards? And this expert just said If someone has a heart attack shoveling snow and falls over backwards, this can happen. If someone is drunk and slips and falls over backwards, this can happen. If someone falls over backwards, for whatever cause, this can happen. There are a lot of things that can cause someone to fall over backwards. It's the job of the Commonwealth to prove what caused John O'Keefe to fall over backwards. But I don't disagree with the head injuries. The ME agreed about the falling over backwards, that was a common presentation of that head injury.
Traumatic head injuries, you would not die immediately. It's a process. And it's a process of a combination of things. Brain swelling, which takes a while to develop. Decreased blood flow to your brain because you're getting swelling.
Yes, my notes say don't teach people to crime better. That's what my notes say.
Brainstem that controls your heart and your breathing. And so this is why there's a whole big issue about brain death. You know, when is someone brain dead? Because it's not instant and it can take a long time to be conceived. In these injuries that are very severe that we took care of, there was a high mortality rate. In the linear skull fractures, it was about 67%. But it took time for them to die. It could take days to weeks to months. And also, these people got to shock trauma. So it was a while, whether it was hours, before they were even starting to be taken care of. And yet, they weren't dead yet. That's why I don't think it was immediate.
So this morning started out with court being delayed, the attorneys coming in immediately, the court calling them to sidebar. After the court called the lawyers to sidebar, the court went on the record briefly to say that there was an issue and the court needed to talk to each of the jurors individually. I am not speculating on why that is, because eventually the sidebars will be unsealed and we'll find out. We got some hints when the court came back on the record after all 18 of the jurors had been individually inquired of. They removed everyone from the courtroom. Media, family, everyone. They sealed the courtroom and spoke to each juror individually. What would that look like? Well, the juror could be in the juror box or in the witness box. The court reporter would be there. The court staff would be there. The attorneys and Karen Reed would be there. No one else was present. What did they talk about? We'll find out at a later time. What can we summarize from what the court said when she came back? The court said when she came back, I just need to ask you that one question. Did you do any research? We've already talked about the other two questions. The judge says it the same every single day. So let's go through those same three questions from yesterday's hearing verbatim.
I have to ask you those same three questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes.
Refrain from discussing this case with anyone. Number one.
Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case?
Independent research was the only thing she asked about today. She said, I talked about the other two with you already. Discuss it with anyone. Independent research, not the issue.
Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone?
Discuss, see, hear, or read anything about the case. Those are the two areas that were discussed at sidebar, because when the court came back to court today, she said, we've already talked about the other two. So we have some context about the issue. All 18 jurors are back in court. And what I have seen reported by numerous sites is that the jurors have moved around. So where the jurors are now sitting has changed. So there was a seating arrangement change, and there were some notes made that some of the jurors, and we've seen the court address the jurors about this before, some of the jurors seemed to be chatting with each other when there were breaks and sidebars. The court gave them an admonishment that it could be disruptive to other jurors And she said the lawyers have worked very hard to put this before you. What frustrates me is what the court did not say is Karen Reed deserves your attention in this matter. John O'Keefe deserves your attention in this matter. The lawyers are doing a job, right? The lawyers deserve your attention, they do, but the reason the lawyers deserve your attention is because John O'Keefe and Karen Reed deserve your attention, and this case deserves your attention. And so if the jurors are saying things under their breath, you might have a jury that's getting put out with one another. You can't talk about the case until deliberation at all, period. Talking under your breath, making jokes, not going to go well, because the bailiff's going to try to shut it down, then the court's going to try to shut it down. Can the jurors talk at lunch? Yeah, they can talk about the weather, they can talk about their families, they can talk about their jobs. They will eventually run out of things to talk about, but it's pleasantries. You cannot talk about the lawyers, you cannot talk about the case, you cannot talk about the shoes the lawyers are wearing or whatever. You can't talk about it. I imagine, because there are still 18 jurors, that it is more likely than not a decorum thing, seeing that some of the jurors moved around. The jurors might be at issue with one another. Have you ever had to do a group assignment with 18 people? That is not easy. So I have empathy for the jury. I have empathy for the lawyers, the judge, the parties, the families. All of it is hard. With all of that, this morning, the jurors came in one by one to go to sidebar with the court. All 18 jurors were back. Their seats were moved around a bit. And then evidence resumed with a witness out of order, which means they were in the middle of another witness from yesterday. They were in the middle of witness 36 yesterday from the state crime lab, the trace analyst who did matching of the drink glass that was found by the leaf blower team originally by Gallagher. So that witness was interrupted and a witness was called out of order, meaning not in the order of the Commonwealth would like that witness to be called. And that witness was the neurosurgeon, Dr. Wolfe, hungry like the, not W-O-L-F-E. Dr. Wolfe's direct examination was about the injuries to the back of John O'Keefe's head and what caused the brain injuries, the type of injury, that the brain injury and the bleeding from the brain injury could cause the bruising and apparent bruising to the eyelids, and that the laceration on the back of the head is consistent with a fall backwards, and talked a lot about the fall backwards. When we got to a brief cross-examination with Attorney Alessi, it was, okay, but you saw that John O'Keefe, the decedent, had lacerations on his face from the coroner's report. Those wouldn't come from that fall backward, correct? So then they talked briefly about, okay, these other injuries that were noted, those didn't come from the fall backward, correct? Correct. Did this witness testify about how that fall backward was caused? No, they don't know. But they said that the fall backward is what caused that on a flat surface. Not something round like a bat, not something acute. I think the other thing Brennan said was a hammer. So to move away from, could it have been a different type of injury? And the neurosurgeon testified, we didn't see that concave break to the skull that you would see with a more acute hit like that. So that's what they were talking about. And then we got back into the scientific evidence from witness number 36, continuing from yesterday, from the state crime lab, and going through the physical match analysis of the broken glass and what pieces fit on it, and then going through the microscopic analysis of the pieces of plastic recovered from John O'Keefe's clothing and the pieces of plastic on the taillight housing, and seeing if those are the same type of plastic. So the plastic on John O'Keefe's clothing, it's her opinion, both the clear and red pieces of apparent taillight from John O'Keefe's clothing match in type the plastic from the taillight. So it would either come from that taillight or something with the similar properties and composition. And that's where we were at when Adam Lally said, I have about 3 minutes left, and the court said, great, we're going to lunch. So now we're on lunch.
And they worked very hard to get us to this point where we're ahead of schedule, so that tomorrow, instead of being a half a day, you have tomorrow off. So you have tomorrow and Friday a good long weekend. It's very, very important. Do not discuss this case with anyone. Don't say a word about this case. Don't let anybody say anything to you about this case. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. I believe next week, except for Thursday, are full days every day. Watch your social media use this weekend as well. Have a great long weekend. We'll see you here Tuesday morning, ready to go.
The end of day 20, we saw the witness that had been recalled before lunch, witness 36, Christina Hanley, and the defense brought in a new demonstrative exhibit that is now in evidence that showed what items of evidence that this witness compared, mostly pieces of glass, came from where, and showed what was on the bumper of the SUV, what it matched to, and what it didn't match to. I think it was a very good demonstrative. It made it very clear, very easy to follow, and the defense made the point that 2 of these things matched from the bumper in 34 Fairview. Those are both picked up by Proctor. But the other things found on the bumper didn't match to any of those exhibits. So the defense has laid the groundwork to start arguing in their closing, look at what was found by who and what it matched and what it didn't. Isn't that interesting? And that is going to go to, and what else did law enforcement not follow up on? Because the defense is leaning into that Bowden defense of there were other leads here that weren't followed, and I imagine the argument will be, and gee, I wonder why. So at the end of day 20, it felt like the last couple days have been clunky, and the court said multiple times today to the jury, it is very important you do not talk to anyone. Today was a very interesting day in court. I think we learned a lot about what's going on with this jury, and we heard the court say to the jury at the end of the day, we know you don't like it when we're at sidebar. I wonder how that has come up. But I would imagine a juror or jurors mention something to a bailiff. Some courts, when they need to work on something, tell the jurors, we need to work on something in court, we're gonna have you go back to the jury room. Sometimes they have them sit there. I don't know what is preferred, but it's hard when you feel like everyone's talking and you don't get to know what they're talking about. Like, I get it. And there are a lot of sidebars. I wonder how much they can see the lawyers' faces during sidebars. But some courts, you see the jurors excused and they handle it all in a chunk. I wonder if it's easier for them because they can go just sit out of the view of everyone for a minute. But also some jurors get annoyed with having to walk back and forth to the jury room all the time. Is there a good answer? I don't know if there's a good answer. There are things that have to be argued outside the presence of the jury. The court has taken an unexpectedly long Memorial Day weekend with no court Thursday, no court Friday, no court Monday for the federal holiday, so the court said, I will see you all back here on Tuesday. No, the court did not say, I will see you next Tuesday. Emily, would that have been funnier? Yes. The court said next week, except for Thursday, they will be full days. Thursday next week looks like it may be a half day. Here's what I think. Tuesday, Wednesday are full days. I think we might be done with the Commonwealth's case on Thursday. And they are anticipating being done with the Commonwealth's case on Thursday, which gives them a half a day to argue the motion to dismiss that will come at the end of the Commonwealth's case and to talk about scheduling. So I think they might be reserving that half day Thursday for argument if they are moving towards the end of the Commonwealth's case, and I think that they are. So I think Tuesday and Wednesday will be full days. It'll be sort of the end of the Commonwealth's case and maybe a half day in the morning Thursday, and then there's time for them to take care of what they need to do in the afternoon and then get into the defense case on Friday, which means the defense, if they're going to send the jury out over a weekend, will probably bring in witnesses who are not going to be maybe as consequential, or just bring in Proctor first, because it seems like the Commonwealth is not calling Proctor at this point. And so then I think we will get into a full week of the defense case after that, including Dr. Russell, ARCA, the defense experts, etc. So I think we are getting to the end of the Commonwealth's case pretty quickly, which indicates to me they're probably not going to call any other civilian witnesses, and we're going to round it out with their accident reconstructionist and maybe a few other scientific witnesses. And I think that's where we're going to be. So can the defense call Proctor? Yes, they can. Can the defense call anyone that's on the Commonwealth's witness list? Yes, they can. The defense witness list includes the Commonwealth witness list. So anyone that the Commonwealth listed, the defense can call. So we are at the end of day 20, And at the end of the Commonwealth's case or the prosecution's case, there will always be a motion. Different jurisdictions have slightly varied names on it, but it will be saying, look, Your Honor, the prosecution has not proved their case, and no jury could find the crimes charged here, and they argue for it. And then, in almost every case I've ever seen, it gets denied, and then they move forward. So, what's happening the rest of the week? Thursday, no court. Friday, no court. Monday, no court. Tuesday, we will be back in court for a full day. Wednesday, a full day. Thursday, we'll see what happens. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Lawnerd app at lawnerd.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Lawnerd.
Good night.